Thanks to all of you for being here, and welcome especially to the new attendees. It's wonderful to see so many new physicians attending our conferences and learning about how you can succeed with free party practices, and hopefully one day you'll get on our board of directors. We have our board meeting tomorrow, and that's open to all members and so on, and whatever I cannot get through today and tonight, I'll be discussing at the board meeting tomorrow. This is the war room to save private medicine. This is what I do. This is what AAPS does. We've become the leading medical association in doing this. There's no other medical society that files as many lawsuits and as many amicus briefs, which are friend of the court briefs, where we come in and we hear about something that perhaps a member is doing or another important case, and we come in with a brief and file it with the court and say, we're an independent medical association, we've looked at this, and you should rule for the physician or whomever for the following reasons. And these amicus briefs are very effective. I just did this last week with the U.S. Supreme Court in a case where the federal government criminalized, prosecuted, and put in jail a physician based on mistakes in his operative notes. There was no billing fraud. There was no extra charges that he was trying to get. The jury acquitted him of all that. It's because of mistakes in his dictation about his operations, which he did a long time after the operations. You know how a surgeon will sort of let the charts stack up, and then finally, one weekend, weeks or months after the operations, he dictated what he did. There was some mistakes in it. It wasn't perfect. The federal government prosecuted him and put him in jail because of that. This has gone to the U.S. Supreme Court to overturn this because that's outrageous for the federal government to criminalize mistakes in a doctor's own dictations that does not represent any intent to defraud any insurance company or any governmental entity. It's Orwellian. This is like 1984, if you ever read that book, where the federal government is trying to control what we say. And they did that to this doctor in the case of John Natale versus United States. AAPS is a leader in these cases. And in this case, the Medical Society of the State of New York joined our brief. They liked what we were doing and say, yeah, we want to be in there too. We'd like to join your brief. In fact, most of the amicus briefs we do now, there are other medical societies or other groups, sometimes patient groups, who want to join our brief and follow our lead to try to save private medicine. And we will save it. We're going to win because with your support and your ideas, doing a little history research in preparation for this talk, and went back to the Roman Empire and how that thing collapsed. And there were barbarians out there, right, who caused the fall of the Roman Empire. And there were the Huns and the Visigoths and the Ostrogoths and the Franks, the Saxons, and all these groups were sort of barbarians that chewed away at the empire and brought it down. I was reading about the Huns. The Huns were such savage people that they just ate raw meat. They didn't use fire. Just for their diet, they'd kill animals and they'd just eat the meat. They had no use for cooking or anything. That's how savage and dim-witted they were. I read about Attila the Hun, and one historian said they went to some dinner and he was sitting there and it was entertainment, and everybody was just laughing at the comedy and so on, until the Hun just sat there stone-faced. Nothing was humorous to him at all. And I thought, you know what these Huns, you know what they remind me of? They remind me of hospital administrators. And hospital administrators are a big threat to the practice of medicine. And we've got members who call me all the time about the tricks, the stunts, the sham peer reviews, and so on that hospital administrators are doing. And I just had one just Monday, this week, where I helped out a member, came into the boardroom of a hospital with the hospital administrators there, and it was an appellate review for sham peer review, and there was supposed to be a 3-member appellate panel to review this sham peer review. And the seating was such that instead of the three members of the hospital appellate panel sitting there together, as you would expect in any court of appeals. Three, you see a jury, you address the jury. No, the latest trick that hospital administrators pulled was they interspersed powerful hospital administrators in the middle of the seating of the hospital panel. So you had panel member, intimidating hospital administrator, panel member, intimidating hospital administrator, panel member. I said, what are you gotta be kidding me. What kind of stunt are you guys pulling now? And I objected, and I forced them to rearrange their seating and segregate the panel so that at least I could address the panel and get some semblance of review of this sham peer review. But there's a ton of money. There are law firms out there, Horty Springer you've probably heard of. They're advising these hospitals how to flex their muscles against doctors and control doctors as much as possible. I argued a case before the U.S. Court of Appeals for the Seventh Circuit earlier this month on behalf of an AAPS member. And when I was walking out of the courtroom after I explained what these, quote, nonprofit hospitals are doing to take over the practice of medicine and eliminate independent doctors from the market, after I explained that at oral argument, and we haven't had a decision yet, I was walking out, there was an attorney in the audience who stood up and said, you explained that exactly right, what's going on. And it's an eye-opener to the judges. Nobody really is aware of this. It's just happened the last couple of years, but it's these massive hospital chains. There's one of them in every state that are usually secular, usually non-religious. Of course, there are religious hospitals too, and that can be an issue. But the cases I've seen are the non-religious ones that have a chain going. They usually acquire other hospitals, and they are perfecting the art of eliminating the independent physicians from their staff so that the hospitals can control all of the decision-making. The more the hospitals can control the decision-making, the more money they make. And you can look at their Form 990s, which are made public, and you can see how much these hospitals are paying themselves. And they're paying themselves multi-million dollars annually, and it keeps going up and up and up as they control the decision-making in the hospital and enrich themselves. You look in any other area of our market out there, of our life, and there is more accountability than there is for hospitals. You look at public schools. Public schools are about the same size in terms of an industry as the hospital industry. They're both about $500 billion industries. Public schools, though, have the oversight of public school boards who are elected officials. They have open meetings. They take input from the public. They have a skeptical press. Hospitals have none of that. Hospitals do not have open meetings. They do not have oversight by elected officials. They are completely on their own without any checks and balances. And that's where you get some of the worst abuses and some of the worst disruptions of private medicine is by these hospital administrators. So AAPS is in a lot of these cases in a big way, and we help our members who are having issues, and I'm sure there are physicians here in attendance who are having issues with their hospital. We will fight those cases, and we need more of them, both by our members and by AAPS. So that's one front in this battle to preserve the private practice of medicine. Some of our members get out of hospitals. Say, forget it, I'm not going to deal with that. And if you can get out of a hospital, if you're in a specialty that enables you to do that, that's great. And get out and start a cash practice where you don't have to deal with that hospital interference with what you're doing. That's wonderful. Not all specialties can do that. Some can. If you're in a specialty, you can do that. I encourage you to think about doing that, particularly if you have a bad hospital that's causing you problems. Okay, that's one front. Insurance companies. They have a bag of tricks too, don't they? Have any of you gotten recently in the mail a notice of a settlement with Aetna? There we go. Yeah, look at how many have gotten that. You get a nice little packet. It's about 15, 20 pages long. It's a little booklet. It's got your name stamped on the back. And it's notice of class settlement with Aetna. And most doctors, most anyone, get something like that in the mail. It's all legalese. He's got time to sit down and read 15 to 20 pages of mumbo jumbo. You pitch in the garbage. All right, you don't want to participate in the settlement. No, sorry, I'm not going to participate. These insurance companies are so diabolical that when you pitch that in the garbage, you're still included in the settlement. That in order to escape what Aetna is trying to do to you, you have to send in a letter asking to be excluded from the settlement. You have to affirmatively assert your right to be excluded from the settlement, or else you're stuck in it. I explain that to people and they shake their head. I got to tell you, it surprised me as an attorney that they have ginned that up in such a one-sided way that only those who affirmatively assert their right not to be included in the settlement are going to get out. Now, why don't you want to be in the settlement? You might think, settlement? Yeah, I'd love to get that check in the mail one day for all the money that Aetna has not paid me. Even if it's 50% of all the money that Aetna has not paid, I'd love to get that check one day. Yeah, I want to be part of that settlement. That settlement is going to be like a $100 check at the end of the year for 10 years of unpaid bills by Aetna. 10 years is what they have in that settlement that Aetna gets out of. For some doctors, that's millions of dollars. And for that, they're going to get a check in the mail for $100 as part of the settlement. Not only that, what these insurance companies are doing, to anyone who does not opt out of that settlement, if you then try to sue the insurance company for the monies it has not paid you, even monies it has not paid you for patients you saw after the term of the settlement, the insurance company will try to get you held in contempt of court for going around the settlement. This is unbelievable. And so what I've been telling doctors is send in that letter to opt out of that settlement. And I've been telling AAPS members, get that address. The deadline is mid to late February, but don't wait till the last day. It's a P.O. box in Jericho, New York. The address says exclusions on it. Send it in, opt out of it personally, opt out of it with your PC or LLC, or wherever you practice medicine. Get that in and get out of that settlement. Because otherwise, you're not going to be able to collect against Aetna. You're not going to have any rights for 10 years of claims with Aetna. Even more so, if you don't opt out and Aetna has paid you a fair amount of money over that 10-year period, Aetna may sue you because they know you cannot counterclaim against them. So you then become naked there if you don't opt out, because your rights against Aetna have been waived by this big settlement, and Aetna has a free shot at you if they paid you a lot of money over that period of time. It's the insurance companies. That's what we're up against. Yeah, question in the back. Sure. Yeah, sure. We'll provide that for you. And we'll send out an email about it too. Put it up on the website and send out an email. Anyone here who's not getting our emails, I encourage you to get on our email list, and so you can receive our emails about this type of information. You're only going to hear this stuff from AAPS. We don't try to do the things that other medical societies do, and in fact, we don't want to do some of the things other medical societies do. In fact, other medical societies are part of some of these insurance settlements. And I don't fully understand it, but somehow in some of these cases, other medical societies have somehow gotten a piece of the pie. I've heard this happened in Texas a couple of years ago, that somehow the Texas Medical Association got some money that was set up in a fund and so on, and I'm not here to talk about the details and whatever, but we don't do that at AAPS. AAPS is for private medicine. We're not here to try to raise money. We're not here to try to collect money from insurance companies. We're not a business. We don't sell CPT manuals to you. We're here to stand up for private medicine. That is our 100% focus. Get on our email list so you get this information that we can get out to you efficiently. And of course, these seminars too, and our newsletter and our website. Okay, next topic. Maintenance of certification. We're in the Wall Street Journal this month. They did a story that was very one-sided in favor of maintenance of certification. Maintenance of certification is a multi-$100 million racket. It's a scheme. It's a money-making scheme. It does not do anything to improve the quality of care. There's no study that shows any evidence that there's any significant improvement in the quality of care due to maintenance of certification. Now, we're not objecting to initial certification. It's like if you get your MD, you pass a board exam initially, that's great. We're all for that. That's fine. Okay, that's like the diplomas we all get in any profession. But you know what? I mean, I went to law school. I don't have to go to law school again every 10 years. I mean, I don't have to get a new diploma every 10 years. In fact, as an attorney, the number of hours of CME that I need to obtain each year is 12. 12 hours of CME. That's all an attorney needs. Of those 12 hours, 2 of them must be in ethics. You have to do a little bit more, don't you? You have to do 50 hours, but you have to do this maintenance of certification, which is beyond annoying. And there is a rebellion that's brewing among tens of thousands of doctors against this maintenance of certification scheme. And we caught wind in Ohio that they were making maintenance of certification a condition of licensure. That you could not renew your medical license unless you jump through these hoops with your specialty society, and you know what they are. Silly exams, questions that have nothing to do with your practice, questions that are not subjected to public scrutiny, so we can all see how ridiculous the questions are. It's under a veil of secrecy. And in fact, some of these boards have destroyed doctors who have disclosed these questions. They're bullies. You know, they have really gone after doctors who have given these questions to other people after they take the exam. The expense, the time away from patients. I mean, does this country really need doctors to spend less time with patients than doctors can already spend? No. There's already too little time for doctors to spend with patients. To pull them away from patients even further, to take prep exams, prep courses for these exams, to travel and so on, and the failure rate's going up. You know, it's no longer just a few percent who fail. Now 10, 20, 30% fail. Then what do you do? All to unaccountable boards that are just making money for themselves, that are paying themselves, executives of these societies that run these MOC rackets are paying themselves $700,000 a year just to impose this burden on doctors. No accountability. They're not elected. There's no public meetings to discuss this issue. They're just imposing. What they do is they go around and they get hospitals to require them. And here are hospitals, again, popping up as part of the interference with the practice of medicine, because hospitals are starting to impose MOC as a condition of remaining on staff. So we have a number of doctors who have vowed they're never going to take one again, one of these MOC exams, not going to go through the process. Well, unfortunately, hospitals are not going to allow them on the staff. So there's that issue. AAPS, we look at this and we take initiative. And we filed a lawsuit in federal court against the American Board of Medical Specialties to cite the antitrust violations that are going on here. We're waiting for a decision in that case. We sued ABMS, which is based in Chicago, like many medical societies. We sued them in Trenton, New Jersey. And they didn't like that. They did not like being in Trenton, New Jersey. And they have done everything they can to try to get out of Trenton, New Jersey. But they're not out yet. And I'm not going to let them out. Yeah, we put a lot of thought into this. Well, I thought. I mean, as I say, we do more litigation than any medical society, maybe more than almost every medical society put together, really. And we talk strategy, and you all are welcome to participate in some of our strategic decisions. We're looking forward to what to do in 2014. We're already ahead of our pace in terms of actions and so on. Okay, what else? A threat to private medicine. Obamacare. Right, yeah, we can't leave that off the list, right? That is in effect now. And we have 2 lawsuits against it. We have the initial lawsuit that we filed a few days after it was signed into law, and we had oral argument before the DC Circuit earlier this month, and we're waiting for a decision on that. And as part of that initial lawsuit, we also challenged PACOS, and we were able to delay the implementation of PACOS for a couple years because we challenged its legality, and because of that, the government backed off on PACOS and it held off from 2010 until this month before really requiring PACOS. And what PACOS requires is that you be in the PACOS system if your prescriptions are going to be paid, if your referrals to other doctors are going to work, if your orders for durable goods are going to be paid by Medicare and so on. You've got to be in the PACOS system. Now, you're in the PACOS system if you're enrolled in Medicare, which some of you may be. You're also in the PACOS system if you've opted out of Medicare and have an NPI number. But you're not in the PACOS system if you're disenrolled from Medicare and have not opted out, or if you don't have an NPI number. AAPS members held out for years without getting an NPI number. And I knew some of the very last holdouts who continued to refuse to get an NPI number, which was never required by law to get one. But the insurance companies, the pharmacies, and so on just made it more and more difficult till finally even our last holdouts have given up and gotten an NPI number. So that may not be the obstacle to being in PACOS, but there are some physicians in AAPS who've disenrolled from Medicare. They're not opt-outed, they're not in, they're disenrolled. And that's a problem in PACOS. And PACOS is just now, after we've held it up for 4 years with our litigation, they're just now enforcing it. Now, we could get a ruling out of the DC Circuit on it that helps us on PACOS or helps us on Obamacare. We don't have that decision yet. But that's where that stands. And if we will have time for questions after a couple speakers this afternoon. If you have any questions about PACOS, feel free to ask at that time. We then, after our last board meeting, one of our directors said, we need another lawsuit against Obamacare. We need to challenge how the Obama administration is changing the law without congressional approval. They've changed so many aspects of the law on their own. For example, they're enforcing the individual mandate now, but they're not enforcing the employer mandate. So the employees of large corporations are vulnerable to the individual mandate and don't have the protection of employer-based insurance. The law required that both those mandates be enforced at the same time, which makes sense, so that employees have the protection of their employer and they're not going to get hit with this extra tax under the individual mandate. But the Obama administration just changed that. Said, no, we're going to delay, we're not going to enforce the employer mandate in 2014, but we are going to enforce the individual mandate. So we sued over that. And that's in federal court. And we picked another good venue for that, Green Bay, Wisconsin. And well, we knew the playoff game would be there, of course, and we wanted to, we wanted to be there for that playoff game, but then it got too cold to go anyway. So we checked this out, and I won't go into all the details why we picked that, but we checked that out very carefully. And Ron Johnson, a U.S. senator, evidently was impressed by what we did, because when he sued earlier this month to challenge the exemption from Obamacare that Congress has enjoined, he sued in the exact same place we did. So imitation's the finest form of flattery. And he looked at it and he said, you know what, AAPS is right. This is where we want this lawsuit. The government has come in, as they do in all these cases, and they try to prevent the judge from addressing the merits of the case. They don't deny that it is unconstitutional for the executive branch to just make changes in the law the way that the Obama administration's been doing. They don't deny that. But they try to say we cannot challenge it. They try to say we don't have legal standing to challenge it. Well, who does? Who would have legal standing to challenge this? It's not a group of physicians. I mean, who would? So that's where that case stands, and we're in briefing on that. I knew Obama in law school, and it is ironic that his whole presidency has come down to this health care law, because that was not a pressing issue on his mind when he got interested in politics. We never had discussions about health care in law school. And he does, I would say he's perhaps not a big fan of free enterprise. I can relay that to you. He was not there to try to make capitalism work better and lift some of the restraints on capitalism. So I think that he does like the way that the healthcare law redistributes and clamps down on the free market, and many speculated that the goal of the law is to get to single payer. I will say that in this country, I do not believe it is possible to ever go completely to single payer and to ever prohibit the private payment for medical services. There are just structural reasons why we can never be like Canada, where it's illegal to hire your doctor to provide services to you. And maybe you can think of some reasons why in the United States of America, with our demographics, with our tradition stuff, that it will never be the case where it's illegal for you to take out your wallet or your credit card and pay something to a doctor for a service. One reason is the huge number of uninsured who are always going to be there, huge number of undocumented aliens who are going to be there. How are they going to get medical care? You can't prohibit the private payment, or there are just tens of millions of people who are then not going to have any access to medical care, and it's going to be a disaster. So to the extent there are some leftists who are trying to take over and prohibit all free enterprise in Medicare, it's not going to work. And that's why we're here, to encourage you to get into cash as much as possible, to encourage you to develop private practices, because that market will always be there. No matter how successful we are with the litigation, no matter how good or bad the election outcomes are, there will always be that market for cash services. And the more you can shift your practice into that cash market, the better positioned you are, the stronger you are as these problems with insurance companies, hospitals, the federal government, et cetera, go on. The prosecution of Dr. John Natale was in the Medicare system. That's where the federal government gets its power. And if you're in cash, there is almost no jurisdiction for the federal government even to get in there unless it has to do with controlled substances. So the federal government doesn't have jurisdiction to get in there. The state governments aren't going to bother with you. They're really focusing on Medicare and Medicaid. And so really you're out there free and clear of all these other problems that the medical profession is increasingly having because of the encroachment due to government power. So that's the protection that a cash practice gives you. And let me give an illustration of one AAPS member who took our advice that was in our newsletters and emails, and he remained a non-covered entity under HIPAA. And a non-covered entity under HIPAA is someone who does not file electronic claim forms with insurance companies or electronic referrals and remains on paper. And to some people, they may have thought, wow, that's silly, what difference does it make? It does make a big difference, because if you're a non-covered entity under HIPAA, you are not under the jurisdiction of the federal government for HIPAA. Federal government has no power to come into your practice and complain about whether you have a privacy officer or whatever. And he had a patient who complained about him for a privacy violation. And what it was the patient was doing something dishonest. And the doctor sent something to his employer where the employer figured out the patient was doing something dishonest. The patient then, even though the patient was doing something dishonest, complained to the federal government that that was a violation of his privacy, that this information went from the doctor to the employer. Federal government came in with all their power, and they demanded to know chapter and verse of how this doctor was complying with HIPAA, who his privacy officer was, what his procedures are, how he did this, et cetera, et cetera. There are going to be fines, there are going to be public reprimands, et cetera, et cetera. And I went to the federal government and said, guess what? He's a non-covered entity under HIPAA. And they had never heard this before. They didn't believe it at first. I said, what that means is you have no jurisdiction over this doctor. You are exceeding your jurisdiction to harass him. And they backed off. They backed off. That is probably the only way you can beat the government, is on a jurisdictional ground, that they're exceeding their authority. And when you go into cash, you're able to get out from underneath the thumb of a lot of these federal and state regulations. The only exception is controlled substances, and you do have to be careful. If you prescribe controlled substances, you have to be very careful how you accept that cash from the patient, because someone may try to do an undercover sting operation on you and may try to pretend that the cash payment was for the prescription, was for the controlled substance. So in that situation, you've got to be very careful that only your receptionist receives the cash. And what an undercover agent will do will come in, and in some cases they try to give the cash to the doctor. And you don't want to take cash. from a patient in the examining room. Say, no, payments are up front. These undercover sting operations, we know some good doctors who were in jail for a long time, not because they did anything wrong, but because they got fooled by an undercover sting operation. And that's when a patient is pushing too much in a certain direction, says things that they're off. You got to be street smart enough when you hear a patient say something like, wow, I can't come in during the day, I'm working at my moving company, can I meet you at the parking lot after hours? Seems obvious now, but let me tell you, some of these undercover agents are Academy Award-winning actors. And we have one case where after 2 undercover agents stung a doctor, got him to say what they wanted to on tape, they left the tape recorder on. And they went out to their car and they were giving each other high fives about how they bagged the doctor. Yeah, we really got him. Got him to say just what we wanted, and the recorder was still running. And all that got picked up by tape too. And he kept his license too. So with your help and your ideas, we're going to continue to fight these cases. As I say, there are other groups that have joined us. Many of our amicus briefs are joined by other groups now. Let us know. Let us know what cases you may have going or you know someone who has going. It's not only the cases brought by APS, but it's also lawsuits by individual members. Many of our members are bringing fine lawsuits, and we're educating the judiciary. And with the public demand for free enterprise and for good medicine, we will prevail. Thank you very much.